I am honored to be here between you and discuss together very important for all of us, but only for our son, our grandson, for the future of the world. Problem of environmental, problem about governance of company, problem about the equality in the world of the measure that we have to observe to give a better future under ecological point of view. ESG is our new frontier. We are all involved in that big problem. Today, I have to introduce you some exceptional experts of this problem. And beginning from Jesus Eduardo Troconis Heredia, is a well-known at international level expert on those problems. He published, edited very numerous contributions under scientific point of view, and also can observe the scenario that in South America is present now. Also, Ettore Maria is a well-known professor at the University of Florence, and is an expert of that matter. And so also Andrea Spada Jiménez is on my left side, is another expert, very well known. But each person will explain some details about each career, curriculum vitae, and also about the object of the topic of each speech. And not last, but we are waiting also for other two. And the name? Yes. And what about you?
Hello. Hi.
You not need to presentation because you are very well known.
Lucio.
Okay. Now I pray each one of you to present themselves and to speak about the topic, the experience.
Yes, we will do it.
Okay. You can be.
Please give an applause to him because he's the ex-president of the World Jurors Association, so please a great applause for him. Okay, so I will be first when I am second. My name is Carrie Gaard. First of all, I want to say a blessing to all of you. May God bless you. May God keep you. May God give you every heart for union and love, and understand that we are not here for each other. We are here for him first and then for each other. So this is not just a law congress. This is a peace congress. This is a peace in our hearts. We are created in God's image. So may God bless everyone here with Christ in your hearts, and let's make this Congress and every single day of us in peace, in love, and union that we need in everyone's earth. So, well, I can say that I've been, since I am 20 years old, looking for justice in the world. And we know that without peace, justice is impossible. And without Christ, without God, justice is impossible, and peace even less. I'm one of the coaches of climate reality, leadership of climate change, with my mentor, the president, ex-former president Al Gore of the United States. I've studied in the United States. I'm from Argentina, the Republic of Argentina. And I've also been in the government with environmental law and pushing a lot of projects in environmental law in the Republic of Argentina that were not assessed by the government for interests, in political interests for, unfortunately, for my country. Executive interests that are not for the people. We are here to just address that we need a change, and the challenges of sustainability are right now. So it is a privilege to address this assembly of world jurists on a topic that demands our most earnest attention: the challenges to sustainability. As legal professionals and experts, we are stewards of justice, order, and the frameworks that govern human interaction and our relationship with the world, with the earth. Sustainability in its environmental, social, and economic dimensions is not merely an ethical aspiration. It is an increasingly pressing legal concern, shaping international treaties, national legislation, corporate governance, and even fundamental rights. As we stand in 2025, so fast, the challenges to achieving a sustainable future are starkly evident. They are complex, interconnected, and demand innovative legal thinking and robust enforcement mechanisms. To fully appreciate the depth of these challenges, it is useful to consider not only the scientific data and policy debates, but also the enduring ethical and philosophical principles that have long guided human societies and influenced legal traditions. In this context, as a theologist also, as a philosopher also, I've studied a lot. I will literally draw upon one of the king verses of the Bible. As you know, the Pope Francis died, and he was one of the leaders of the world that asked for peace. No matter where you are, no matter who you are, or how or which race you are. And peace is fundamental in our hearts, not in our words, in our hearts. So in the Bible, a foundational text that has shaped ethical thought and indirectly legal concepts in many parts of the world to offer perspectives that resonate with our present struggles. I know that this country, the Dominican Republic, has the Word of God, the Bible, in his flag. And that was shock to me. I would refer to these specific verses not as legal precedents, but as historical reflections on principles highly relevant to the nature of these challenges. Let us first confront the palpable challenge of ecological imbalance and environmental degradation. The science is clear. Climate change continues unabated. That means that biodiversity is declining at alarming rates, and pollution degrades the natural systems that support life. For us, as jurists, as humans, this translates into escalating climate litigation, the need for stronger environmental regulations, legal questions surrounding resource allocation in times of scarcity, and the complex task of holding actors accountable for diffuse and long-term environmental harm. The core of this challenge lies in humanity's relationship with the natural world, with the earth. Historically, some legal systems have viewed nature primarily through the lens of property and resource extraction. However, the consequences compel us to reconsider our role. From ancient texts influencing ethical thought, we find a perspective on humanity's responsibility. In Genesis, one of the books of the Bible says, "And the Lord God took the man and put him into the Garden of Eden to dress it and to keep it. This verse is often cited as an early articulation of stewardship. Every one of us is Adam, every one of us is Eve. This verse is often, as an early articulation of stewardship, the idea that humanity was placed in creation, not as an absolute ruler for unbridled exploitation of the earth, but with a duty to dress it. That means to cultivate and work with it, and to keep it, to love it, to protect and care for it. This ethical principle reflected in religious and philosophical traditions beyond Christianity, beyond any religion, provides a powerful counterpoint to purely extractive approaches, beyond any law. As jurists, this resonates with the principles underlying environmental protection laws, the idea that we have a responsibility to manage and conserve the natural world for future generations and for its intrinsic value, informing laws related to conservation, pollution control, and sustainable resource use. The very concept of intergenerational equity, increasingly relevant in environmental law and climate litigation, echoes this ancient call to keep or care for what is entrusted to us beyond our immediate needs. Secondly, we face the profound challenge of social equity deficits and injustice. Sustainability is not solely an environmental concern. It is deeply intertwined with social justice. The impacts of environmental degradation disproportionately affect marginalized communities and the global poor, exacerbating existing inequalities, ensuring a just transition away from unsustainable industries, and fostering equitable access to clean resources and economic opportunities are critical legal and policy changes in 2025. Legal systems strive every time, in every country, in every earth, in every single point of the earth. From climate migration and access to environmental justice to ensuring fair labor practices in green industries and preventing land grabbing for renewable energy projects and not greenwashing. We have more of greenwashing than real green projects. The call for justice and care for the vulnerable is a recurring theme in many ethical traditions. You know what? In the Bible, again, the Lord says, execute with judgment and righteousness, and deliver the spoiled out of the land of the oppressor, and do no wrong, no violence to the stranger, the fatherless, nor the widow, neither the innocent blood in this place, every place. While directed to us as rulers concerning social justice in their time, sustainability also is included in social justice. This movement reminds us that laws and their enforcement must actively counteract oppression and injustice. Our work in human rights law, environmental justice, advocacy, and the development of corporate societal responsibility standards reflects this enduring ethical demand for just judgment. A third significant challenge lies in weaknesses in governance and the rule of law when addressing sustainability issues. Despite numerous international agreements and national laws, implementation and enforcement in every country remains inconsistent. Conflicting legal frameworks across jurisdictions, lack of transparency, and capacity gaps hinder effective action. Addressing global changes like climate change requires unprecedented international cooperation. So to do justice and judgment is more acceptable to the Lord than sacrifice. Every single one of us, let us consider the challenge in our hearts posed by economic systems that fail to account for long-term sustainability impacts. Our current economic models often externalize environmental and social costs, leading to market failures that undermine sustainability. If we saw unsustainable practices, pollution, resource depletion, we will inevitably reap negative outcomes. Distinguished colleagues, to sum up, The challenges to sustainability in 2025 are immense, demanding our best legal minds and deepest ethical reflection. Climate change, social inequality, governance deficits, and unsustainable economic models require legal responses that are both innovative and grounded in enduring principles of responsibility, justice, and accountability. The timeless insights found in the Word, that is the only book in the world that will not die, that is always active, alive, still in 2025, remind us that we are not capable to do this without the Creator, without God. These principles lie in our hearts because He created eternity in our hearts. As world jurists, we have the unique opportunity to create peace and responsibility to shape legal frameworks that guide humanity towards a stable future. This requires not only technical legal expertise, but also wisdom, foresight, union, and a commitment to justice. Let us draw upon all sources of insight, scientific understanding, policy analysis, and the ethical wisdom accumulated over centuries to meet these challenges effectively, one to each other, side by side. No matter where you are, we can make it all together when we are literally surrendered to the Creator that will help us to reach all these challenges. Thank you.
Thank you very much for a very interesting lecture. And I was thinking that you poses too many arguments, but two main points. Individual possibility to make something of active, what we can do individually. And you pose a second plan, perspective, to politicians. That is a problem, the oxygen is a need for each one of us, also for politicians. And so I think that the two problems are two parts of the same medal. Individually, it's possible to propose a action, legal action. First question. Second question, what we can suggest to politicians to make better the general situation? In Europe, we have a lot of too much legislation, directive, regulation about that problem. But the idea is more simple. Any economic any company needs to receive money. Without money, it's impossible to realize an economical activity. And so, link the money, the cost of money, to environmental effect of the production. That is the idea. More environmental, more cost of the money. That is a perspective. I suppose that perspective to my Lucio's colleague and each one of us, because that is a problem, a common problem. So, second speaker, no? Are some questions to arise? No? No question. Okay. Well, now I think it's time to hear the Jesus Eduardo Troconis, Heredia. If he's a great author and expert of that matter. So, listen.
Buenos días, un saludo muy cordial a todos y desde luego en primer término un cariñoso abrazo al panel y al maître Luigi Ghia, que nos ha orientado muy bien sobre el tema que vamos a abordar. Realmente voy a empezar con el apunte fundamental de este congreso. Todo lo que aquí hagamos indica un camino, el mantenimiento del Estado de Derecho. No es posible la vida en libertad si nosotros no respetamos la normatividad. Nosotros solo podemos tener este tipo de debates libres, con la garantía de que vivimos en un Estado de Derecho, en un sistema como ha logrado establecer la República Dominicana, que merece todo nuestro reconocimiento. El mío en particular porque amo la República Dominicana y además yo soy de Venezuela. Aunque tengo ya mucho tiempo viviendo en Madrid y he dispensado clases durante largo tiempo en la madre patria, porque España es especialmente hoy en día, un guión para comportarse, para estudiar, es ejemplar, para sentir que se vive en libertad y se puede lograr una superación extraordinaria. Pero en todo caso, vamos directo a lo que nos corresponde y se trata de hablar de sostenibilidad. La sostenibilidad es una palabra principal en todo lo que nos sucede en estos días y presenta muchos retos, muchos desafíos. Abarca además, cruza diferentes espacios de la vida en sociedad y de las instituciones que hoy tenemos en día. ¿Qué es sostenibilidad en materia de utilización de los recursos de la energía, por ejemplo? Es fundamental señalar y tomar muy en cuenta lo que acaba de decir el profesor, nuestro director aquí en el debate, Luigi Ghia. Bueno, nosotros necesitamos buscar la mejor utilización de las fuentes energéticas. El hidrocarburo, por ejemplo, nosotros tenemos que utilizarlo porque es una fuente fundamental que tiene un peso extraordinario en el mundo. En el comercio exterior prácticamente cubre el 70% de las necesidades de la sociedad mundial. Y el resto apenas queda para utilizar recursos que avanzan cada día, que son las llamadas energías renovables. Pero además, todo esto debemos entenderlo como una necesidad histórica, pero tenemos que tomar muy en cuenta la necesidad de preservar el medio ambiente, de hacerlo con las mejores tecnologías, porque no tenemos otra cosa que combatir el cambio climático y preservar, repito, el medio ambiente. Una forma de buscar mejores caminos es lo que decía Ghia. Bueno, tendrás que pagar más para obtener esa aportación energética, porque si deterioras el medio ambiente o pones en conflicto la humanidad, tú tienes que tener algún incentivo para buscar la utilización mejor de las energías todas enteras. Algo que es, y me parece importante mencionarlo, en Madrid, por ejemplo, acaba de haber un acontecimiento terrible, un apagón de más de 7 horas. Y lo cierto es que en el aprovechamiento de la energía no hay, en la aplicación de tecnología, ahí no hay la certeza absoluta de que no tendremos no tendremos una máxima seguridad, porque surgen imprevistos. En 2002, Canadá y Estados Unidos. En 2012, en la India. Y ahora en Madrid, que nunca había sucedido, acaba de producirse, repito, un apagón que nos aisló totalmente del mundo con altos riesgos durante 7 horas. ¿Qué tenemos que pensar nosotros en ese sentido entonces? Localizar, descubrir exactamente para corregir cuál es la causa. En primer término, porque muchas especulaciones hablaron hasta de que se había producido un atentado cibernético, lo cual no es verdad. Pero sintámonos nosotros advertidos de que sí puede suceder, Hoy en día ese es un reto, ese es un desafío para la sostenibilidad. Ese término extraordinario ha sido desarrollado perfectamente bien y viene a cuento con las resoluciones de Naciones Unidas, en particular la 1803, que se afinca en el principio de que los recursos naturales de todos los países pertenecen soberanamente a su soberanía. Otra providencia jurídica bien consagrada, el Tratado Medioambiental de Suecia en el 72, creo. Eso es importante. Pero si esa es la regulación jurídica, nosotros tenemos que tomar en cuenta fundamentalmente la necesidad de superar y construir un sistema, un mix energético que ofrezca el uso o utilización lo más razonablemente posible de todas las energías, digo de las fuentes de energía. Y vale la pena hacerlo, entre otras cosas, porque ninguna fuente de energía es capaz de resolverlo todo y de prescindir de las demás. Entonces, a nosotros no nos queda otro recurso, sino la conjugación de todas las fuentes energéticas para poder construir un sistema de energía que sea realmente posible, valga la utilización del concepto nuevamente de que asegure la sostenibilidad del uso de los recursos energéticos. Solo eso podría favorecer nuestra vida en sociedad. Dicho esto, entonces yo los invito a que busquemos concretar todos nuestros esfuerzos y nuestras reflexiones hacia un lema que ayer lo vi en alguna parte y que no voy a revelar, que dice: seamos sostenibles, es necesidad, es el aseguramiento de una vida, de un destino mejor. Hagamos entonces de la sostenibilidad comprendámoslo como un reto, pero también vamos a entenderlo como capaces de resolver esa situación. Un abrazo a todos y creo que con esto he dicho brevemente lo que tenía que exponer. Muchas gracias.
Thank you. And now, Andrea Spada Jiménez, she is a PhD in law cum laude, professor of criminal and civil proceedings at the Universidad of Malaga. And she perhaps could also, because I read a lot of publication, participation to Congress, and she has a framework very interesting for our conference here, because she could also offer some suggestions, some, not answer, but some suggestions to my first remark about the possibility that each one of us has the react to introduce a claim, a criminal, civil claim, for defend each one right of the person, and how and what are the limitations to that kind of initiative. Please, Andrea, please.
Thank you very much. Bueno, voy a hacer la presentación en español porque estamos en República Dominicana, defensora del habla hispana, así que la realizaré en español. Voy a intentar ser lo más breve posible, pero abordar el tema de los retos de la sostenibilidad. En mi mente fue, ¿qué retos hay para la sostenibilidad hoy en día? En primer lugar, y antes de comenzar, que no se me olvide, soy directora, dirijo un proyecto de investigación de la Unión Europea. Si no lo digo, la Unión Europea no se fía de que haya hecho los resultados debidamente, así que lo tengo que comentar. Esta ponencia se enmarca dentro de 3 proyectos diferentes de la Unión Europea a los que pertenezco y el que dirijo. Asimismo, soy portavoz de la asociación WWF de Málaga, así que también vengo en su representación, ¿vale? Hemos traído todo lo que hemos podido. Más allá de eso, de toda la publicidad, como quien dice, y los patrocinios, dejando eso a un lado, me centro en lo que quiero decir. Retos para la sostenibilidad, objetivos de desarrollo sostenible. Tenemos trabajo de aquí a otra vida y 3 más, por supuestísimo. Es que es así. Pero, ¿qué voy a traer hoy? Os voy a hacer un esbozo en cuanto a lo que son los litigios climáticos, en primer lugar, y en un segundo lugar, en cuanto a los litigios greenwashing. Considero que están en auge y si estamos en un congreso como el que estamos, creo que lo más relevante para vosotros es aprender ese tipo de técnicas en cuanto a esos litigios. Por tanto, en primer lugar, ¿qué son litigios climáticos? Porque, y a mí me parece totalmente necesario, determinar la diferencia en cuanto a justicia climática, justicia ambiental, litigios climáticos, litigios medioambientales, porque nos hacemos todos un lío y no sabemos cuál es la limitación, ¿no? Por tanto, litigios climáticos, para determinar la definición de litigios climáticos por parte del Programa de Naciones Unidas, nos tenemos que adentrar, por supuesto, en la base de datos de Saving Center, en primer lugar. En cambio, si queremos determinar lo que serían los litigios medioambientales, nos tenemos que ir a la base de datos de Atlas Environmental Justice. No sé si alguna vez habéis entrado, es una base de datos espectacular. La de Saving Center también. Ahora bien, ¿Qué son litigios climáticos? Aquellos litigios derivados directamente del cambio climático. Por tanto, vamos a eliminar todos los litigios que tengan cualquier tipo de relación con medio ambiente, lo que puede ser ruido, ¿vale? Si no afecta al cambio climático, no es un litigio climático. Cuando nos adentramos en esas bases de datos en cuanto a litigación climática, a nivel mundial, la litigación climática se ha aumentado a un nivel exponencial. O sea, en el último año hay en la base de datos de Sabin Center y en la que os he comentado de Environmental Justice, encontramos que se ha duplicado de un año a otro. ¿Eso qué significa? Hay algo que no está funcionando, ¿vale? Las instituciones y los entes públicos algo no están haciendo bien. Y por eso los ciudadanos necesitan accionar, ¿no? Necesitan esa defensa, esa tutela de los derechos por parte de los órganos jurisdiccionales. Ahora bien, ¿cómo lo hacen? En un primer lugar, me voy a centrar para daros las líneas básicas en la sentencia del Tribunal Europeo de Derechos Humanos, la sentencia Clima Señorinen, la última sentencia tan famosa que salió y que supuestamente yo soy muy crítica, advierto, supuestamente la han vendido como una sentencia de un antes y después y que ahora vamos a proteger el medio ambiente en la Unión Europea por la inacción de los Estados en materia de cambio climático. Considero que no es real, ¿vale? Considero desde mi punto de vista que el Tribunal de Derechos Humanos tenía una herramienta magnífica para poder hacer una interpretación mucho más amplia que no ha hecho. En primer lugar, tenemos un gran problema. La normativa en cuanto a la protección del medio ambiente y cambio climático tiene un carácter soft law. Con lo cual, si tiene un carácter soft law, primer error. Vale, ahora bien, necesitamos de los órganos jurisdiccionales para que nos determinen el obligado cumplimiento. Bien, y así obtenemos una tutela jurídica. El Tribunal Europeo de Derechos Humanos así lo establece, ese es el gran cambio que se aporta porque establece la existencia de un cambio climático, la existencia de la obligación por parte de todos los Estados en el deber que ostentan de aplicar la normativa a nivel internacional, pero nos deja pequeñas cosas que desde mi punto de vista no nos ayudan en nada. En un primer lugar, en cuanto a la legitimación activa, nos determina que las asociaciones tienen legitimación de lege. ¿Eso qué significa? La legitimación de lege es que te dan una legitimación automática para poder ejercitar la acción. Ahora bien, siempre y cuando esa asociación tenga como fin la protección del medio ambiente en relación con el caso concreto. Y asimismo, siempre y cuando se demuestre una relación entre el daño producido y la acción o inacción por parte del Estado. ¿Vale? Con lo cual, el hecho de otorgar una legitimación de lege a una asociación, es decir, una acción colectiva, como quien dice, pero por otro lado, solicitar que exista una relación directa del daño individualizada en una persona, es que no me está solucionando nada. Hasta ahora, el convenio de Aarhus, o acuerdo de Escazú para este lado del charco, ¿vale? El convenio de Aarhus, básicamente ya determinaba eso. El Tribunal de Justicia de la Unión Europea ya determinaba esa legitimación de lege. Por tanto, la posibilidad que tenía el Tribunal Europeo de Derechos Humanos era la posibilidad de reconocer una acción popular, una actio popularis en materia de cambio climático, pero lo ha dejado a un lado. Entonces, desde mi punto de vista, por eso he dicho que soy bastante crítica porque creo que no nos hace ningún favor. Asimismo, el Tribunal Europeo de Derechos Humanos determina en materia de prueba, que eso a mí me parece muy interesante. Si nos atendemos al panel intergubernamental para el cambio climático, ¿vale? El IPCC que todos conocemos, es el que nos determina los informes en cuanto a la repercusión del cambio climático año tras año. Ahora bien, ¿cómo impugnamos esa prueba? Si estamos del otro lado. Y nos encontramos dos sentencias del Tribunal Europeo de Derechos Humanos en el que la otra parte, ¿cómo vas a impugnar la prueba? Es que es inviable. ¿Por qué? Porque ya le ha reconocido el propio Tribunal Europeo de Derechos Humanos el carácter objetivo a esa prueba. Entonces, esa prueba es impugnable y no se debería, si por ejemplo entendemos que es un hecho notorio, por tanto, porque no sería impugnable y es algo objetivo, ¿No se debería, por tanto, invertir la carga de la prueba? ¿Por qué tiene que probar el que le han producido el daño? Entonces, hay muchas cosas que se desgranan de la sentencia del Tribunal Europeo de Derechos Humanos, pero que nos venden como si hubiésemos avanzado. Hemos avanzado, pero creo que muy poquito. Podríamos haber avanzado más. Eso en relación con la acción por parte de los ciudadanos. Ahora bien, me voy al otro lado. Empresas. Tenemos, entiendo que todos entendemos lo que es greenwashing. A mí me encantó llamarle ecopostureo, porque así lo he visto. Entonces, me gustó ese término, aunque el término greenwashing se acuña en el 86, pero ese término en español me parece adecuado. Claro, cuando tenemos una empresa que nos dice, y lo observamos en algo muy simple que yo siempre digo, la gente no se da cuenta, en un vaso de los típicos vasos de café, que nos ponen que son de cartón, supuestamente, pero que por dentro tienen un plástico. Claro, no estás haciendo ningún favor, porque es que no se puede reciclar porque tienen el plástico pegado al cartón. El problema de los tetabric están hechos de aluminio, de plástico, bueno, todo un desastre, ¿vale? Y voy a ir rápido al grano. Y, por tanto, si nos encontramos ese tipo de cuestiones, pero como consumidores no tenemos la formación adecuada, ¿qué hace la Comisión Europea en la última encuesta que hizo en el año 2023, la Comisión Europea se determinó que el 75% de los ciudadanos gasta más dinero en favor del medio ambiente, no le importa. Por tanto, de ahí se deriva, en el comportamiento de los usuarios, se deriva la nueva directiva Greenwashing de la Unión Europea, la 2024-825. Esta directiva nos modifica cuantiosísima normativa, que si queréis, quien esté interesado, os lo envío y os envío las modificaciones. ¿A qué nos llevan? Nos llevan realmente a intentar que exista transparencia y a intentar que exista una información que sea veraz, ¿vale? Veraz, clara, certera, así la ley nos va esbozando. Pero a mí lo que me resultó más interesante es que nos encontramos no solo la protección del consumidor, sino que también nos encontramos con que esta nueva directiva nos determina que tienen que existir entes administrativos que serán los que van a gestionar el greenwashing de las empresas. ¿Quién va a formar a esos entes administrativos? Es mi gran pregunta. Porque después tenemos un montón de entes administrativos que tienen que hacer muchas cosas, pero que después la Unión Europea, en nuestro caso, no nos explica quién lo forma ni cómo se forman. Y ahí entiendo que hay un gran problema. Ahora bien, también encontramos litigios greenwashing entre empresas y cabe destacar el de Repsol con Iberdrola, por ejemplo, en la que se le acusa por un abuso de mercado, competencia desleal y publicidad engañosa. Todas estas acciones, sean de empresa a empresa, de usuario a empresa o de administración a empresa, supuestamente tienen que ser gestionadas por los entes administrativos. Con lo cual, desde mi punto de vista, cabe resaltar básicamente lo que os he dicho en cuanto a la formación de los entes administrativos y a la formación de despachos. Un despacho no se puede adecuar a este tipo de demandas en cuanto a litigios estratégicos exactamente igual. Es que no se puede adecuar si no tiene formación. Entonces, formación básica en Derecho Internacional, Derecho de Unión Europea y de este lado, por supuesto, lo hago comparable, es necesaria, es totalmente necesaria. Entonces, creo que aquí es un entorno en que necesitamos mucha formación y que creo que es uno de los futuros para garantizar la sostenibilidad. Así que muchas gracias.
Thank you, Andrea. A very clear explanation. I have a pregunta. You said that it is possible to introduce an action, but the problem is to prove the damage, direct damage. And that is a very great limit, because it sometimes is impossible to prove that individually suffered a damage. And that is a fair question, because I know that some jurisprudence is looking ahead also in that direction, and you could say something about that. But the second plane, the second question is the government of our countries has some duty, because when internationally speaking, a convention has been signed in the 2030. We eliminate or reduce the damnous emission at that level, and that is a goal that is not achieved. The citizen can do something or nothing. Thank you.
Sí, muchas gracias. A ver, en relación en primer lugar con la prueba, es verdad que nos encontramos con ese gran problema y es muy bueno atender a las resoluciones del Tribunal de Justicia de la Unión Europea y sobre todo la última de Clima Signorini del Tribunal Europeo de Derechos Humanos, porque determina la existencia, o sea, cito entre comillas, la existencia de la relación entre el cambio climático y la afectación al derecho a la salud. Es determinado tal cual. Claro, con lo cual, por eso es lo que yo determinaba. Si vamos a considerarlo, en todo caso, que ostenta un carácter objetivo, entiendo que tiene un valor, o sea, es un hecho notorio, con lo cual no cabe la carga de la prueba para la persona, la carga de la prueba es del otro, es del Estado. Entonces, pruébame tú, y es mi defensa, ¿vale? Procesalista. Intento desgranar todo lo que puedo del procesal. Entonces, desde mi punto de vista, yo creo que para mí un litigio, y le podemos preguntar aquí al juez, un litigio tendría cabida por ahí, justamente atendiendo a la base jurisprudencial en torno a la carga de la prueba y a la valoración. En la segunda cuestión, el problema de los estados es que cuando firman los convenios, los firman por una cuestión política. O sea, los intereses políticos y económicos, fantásticos, pero, por ejemplo, en materia de derechos de emisión, como me has comentado, se crea el protocolo de Kioto. El protocolo de Kioto ha creado un mercado de compra y venta de derechos de emisión. Con lo cual, es que al final todo se te desvanece porque todo lo llevan a un beneficio económico. En mi, y aprovecho, me hago propaganda, en mi tesis doctoral, como yo aseveraba ese tipo de cuestiones, yo determinaba que quizás la posibilidad a corto plazo para determinar con carácter preventivo que los estados y las empresas transnacionales paralizasen ese tipo de actividades, yo soy muy proclive, y es la tesis que he defendido, a aplicar el principio de jurisdicción universal. Que en la práctica quizás no puede ser viable, no, pero en el momento en que en la prensa salga, atendiendo al principio de jurisdicción universal, se ha incoado un procedimiento en determinado estado por un terrorismo medioambiental que existe, que la mayoría de países tenemos tipificado, pero parece que nadie le hace caso, ¿vale? Existe. Eso es, desde mi punto de vista, tiene un carácter preventivo, porque las empresas transnacionales se pensarán dos veces en realizar ese tipo de actividades en connivencia con los estados, atendiendo a ello. Así que espero haberte respondido, pero creo que soy un poco radical, pero bueno, gracias.
Gracias. Gracias, muy interesante. So, I won't speak in my interest or in the interest of my category. I am lawyer. But we heard that the lawyer, as they have a big future in the direction to be proactive in the meaning that we can also accelerate that positive process through the defense of individual rights. And I was thinking to, for example, in Europe, the Court for the Defense of Human Rights could be also a beginning to accelerate that process that, under a political point of view, is not very sensitive, not very central. And now, last but not least for today, Ettore Maria is a good friend, professor at private law at University of Florence, and he's an expert of the matching of that kind of problem and the right to defend. Please.
Great. So, Lucio, thank you very much. I would like to thank the WJA to inviting me here, and I would like to thank as well my estimated colleagues. So I would like to continue a little bit the approach of Andrea that is very technical, speaking on another way and on another side. So Andrea spoke about a public law approach, especially. What I would like to say is something more related to private law and to contract and corporate governance. So I would like to apologize because I don't speak Spanish, this beautiful language that you have, but I promise that I will next 2 years, I will try to do it. Also, if it will be next WGA association meeting in Albania, so it will be more difficult to speak Albanian. Otherwise, so let me introduce some problems that sustainability has. So as Carrie said before, very clearly, we can consider different issues that are at stage right now. So the first one is for sure the fact that we are approaching the 1.5 increase of Celsius degrees increase of temperature. That's one profile that we have to consider. The second one is an ecosystem collapse that we are facing every day, basically. Then there is a very important profile that we have to consider, the corporate impact. What is the corporate impact? So we have to try to balance and counterbalance the fact that we have to protect ecosystems, so environment, but as well we shouldn't push down the economy, because that is a profile that we have to consider continuously. And then we have a legal lag, so a problem of application, as Andrea said before, application of the regulation, this is an international regulation at a worldwide level. Andrea correctly spoke about soft law, so they are the only measures that we can use. So that's why considering 3 profiles that I call a triple bottom line challenge, I'm sorry, I have some slides here, but I couldn't project them. So if you are interested about it, I can share with you later on. So the 3 profiles that I consider here that are very important are the economic prosperity, because it's something that we want and we need, especially in countries that are developing. So there is the second profile, that is the social equity, something very important as well, because we have to consider the differences that we have at the social level. And then we have as Lucio would say, last but not least, the environmental protection. That is something very, very important. So what I wanted to consider here when I was invited was the possibility to apply the tools of private law that we have in a sustainable perspective. So can we use private law and not just a public law regulation, as Andrea said, as a way to obtain these 3 results, and so to obtain a real and effective sustainability? As a tools, I will briefly mention the contract law, of course. Secondly, the corporate law. I don't analyze these profiles because we are among lawyers, probably, and so it's useless to consider in such a short time all this technical profile. Then there is as well an issue of property right that we have to consider, so the possibility to use as well the individual property rights, always considering the sustainability approach. And finally, the private ordering. What is the private ordering? Nothing more than private enforcement. So as Andrea said before, and as I said before as well, the problem is the application of what we said, what we try to regulate. And probably a contract can be a little bit a tool that we can use in this sense more effectively. So let's consider it later. So if we analyze the public environmental law, public environmental law is the approach that especially today is used by the international community, so the Tokyo agreement and so forth, the Paris agreement and so forth. So I humbly consider some issues that we have to keep in mind. So first of all, as I said, is the implementation gap. So the fact that these treaties have to be applied worldwide. So we cannot assure an application that is an harmonized application. Secondly, there is a jurisdiction border. So how to assure privately, so in a public and private system, the jurisdictional application of the treaties, and it's something that as well Andrea analyzed before. So there is a challenge of enforcement, and finally the nature that is not binding, as I said before, so the soft law approach of these treaties. So what about the private law? Which one are the advantages of private law? For sure, private law has a cross-border application because the parties basically, because they operate on a basis of private autonomy, they can be of different countries and they can be binded by contracts. Also, if they are of different countries, there are market incentives because especially in terms of insurance, in terms of bonds and corporations and so forth, when we speak about green, when you speak about environment, there is as well a fiscal, a taxation advantage and benefit. Then there is a potential innovation that we have to consider. So always because it's based on the, let's call fantasy of the parties, the juridical, legal possibility of the parties to operate privately. And then there is the direct accountability. Why? Because if there is not an application of a contract or a private agreement, there are all a series of tools and remedies that can be applied for guarantee the application of this. If we want to consider more deeply, more vertically, the relationship that we can figure between contract law and environmental governance, I consider 4 points especially. So the first one is the environmental covenant. So the fact that the contract, as I said, is binding for the parties, and this is something that is assuring a very strong, strong approach, a very strong applicability of this tool. Then there is the climate risk disclosure. So the parties, when they are treating, when they are negotiating profiles related to environment, they are usually forced to disclose some profile related to climate risk to understand the real application of the measure that are considered in the contract. Then there is, and Andrea, I make reference especially to you and to what Lucio said, the third-party beneficiary rights. So the fact that in the contract, we have as well not just the so-called shareholders, so the people, the parties of the contract, but we have stakeholders involved in all the contracts. So people that are outside the contract, that are considered third parties, but because their interest is very strong and is inside the contract, they can be involved. And that's why, Andrea didn't mention it, probably, I didn't hear, because my Spanish is not very good, but I didn't hear the approach of class action, so the possibility to use the class action. Did you say something? Oh, okay, sorry. So I was fine. Class action is something that we can consider we can use. And then, finally, we have the force majeure evolution. So the fact that if we consider clauses that are flexible in the contract doesn't have this very stiff and very blocked approach that we can have, for example, in treaties, because the contract is more flexible and more available for changes. So if these things that I said briefly, probably badly, and I'm sorry for the way in which I expressed them, but consider the time is short, I would like, about the contract, and now I would like to shift to the corporate governance and consider how corporate governance can be used as well in terms of sustainability. Why I choose this topic, corporate governance? Because as I said before, economy should be a target that we have always to keep in mind, because economy is very important. Everyone is speaking about nature, about the ecosystem and so forth, sociality, very good. I perfectly agree with everyone, but we have to consider as well economy, because people had to live in a better condition, in a better way. And if we consider corporate law sustainability potential, as well here, I considered and I analyzed 4 areas of expansion. So the first one is the expanded fiduciary duties. Why expanded fiduciary duties? Because for sure, in the case of corporate governance, considering with a sustainability approach, there is the possibility to involve in corporate governance, not just, as I said before, the shareholders, but the stakeholders. So the entire society, of course, when I speak about the entire society, you understand what I mean, not everyone, but the collective interest must be involved. Then we have to consider the corporate purpose. Why corporate purpose? Because it's true that companies are working for gathering money and for sharing the money between the stakeholders. But 10 minutes, 5 minutes, 10 minutes. Okay, so I will be much more. I will be super quick, don't worry. Sorry. You know, I'm a lawyer, so I like to speak a lot. Yes, sorry about that. So, corporate, but I promise that I will finish. One day, I will finish. Corporate purpose, so yes, money are very important, but for sure, corporations that have an approach, this is a sustainable approach, as well more appealing for the market and the consumers. Then there is a board composition, so the fact that the company should be structured with boards that are sensitive to sustainability, because this one is an internal wealth of the corporation. And then the sustainability governance in general, and I'm making reference especially to supervisory internal to the company. So I told you once again, I humbly tell you that I developed slides. I cannot analyze everything because it's very long. I would like to, but I'm very keen to share with you later if you are interested in. I would like to make it just a little reference, especially for the discussion that we'll have after, to the insurance and the environmental risks. So the possibility to use a contract that is the contract of insurance as a way to assure the application of sustainability principles and to avoid damages. So if there is a creation of damages, we can operate at a public level, as Andrea said, but we can operate as well at a private level via the insurance. So the insurance system can be very, very important in this case. So to sum up and to close, otherwise they will beat me from the organizers, I would like to tell you that I think that private law can be considered, especially in terms of contract and corporate governance, a very important tool, a very important area to develop. In my opinion, now is underdeveloped, but can be used very much for pushing us to apply principle and philosophy approaches of sustainability. So thank you very much.
Thank you all of you for your kind attention, and personally, I hope that this discussion today will produce some fruit, and that from this wonderful international university, our world leave a sign in the future, especially through different relationship with various universities here represented, not only here represented, because I am convinced that our culture, based on rule of law, must be spread, because only, I would repeat what Cicero said 2,000 years ago. Subietti legibus sumus, ut liberi vivere possimus. We are subjected to the law because it is the only way to live free. Thank you for your kind attention.